Hey guys, it's our live question and answer. So, thanks for joining or thanks for listening if you're listening to this later. I am going to dive right into it. We're doing it a little bit earlier today, but I think this might be better timing because I think folks on both the West Coast and East Coast and anywhere in between. This works for you guys all. So, hoping to get more and more people joining, and I hope to get a couple of a lot more questions, but I'll jump into it. We have a couple of questions around business formations, contracts that you enter into before you're officially a company and set up, and contracts afterwards, and then as well as some equity vesting schedule questions and valuation. So I will jump right into it. Okay, so the first question was, when should I actually start to look into legal to form my business? That's a great question. There are a lot of people who run businesses without having an actual entity legally set up. This happens pretty often, and it's really sort of because there's an idea or there's a service or a good somebody has, and it just keeps happening. People are working, they're selling their product, and maybe they didn't even think this was going to become a business, but it's successful. And it's, in the middle of business, it's very hard to start thinking about actually forming something, finding legal to help you. So there are a lot of people that actually come to me who have been doing business, have been selling a product or a good or a service for a really long time, and they've made a lot of money, but they don't have an actual entity. Likewise, there are a lot of people who do real estate. They do personal investing in properties. And my opinion on that is, I'm not a real estate attorney, but my opinion on that is eventually, if it's something in which you're generating a lot of revenue and you're dealing with a lot of customers or clients or just people in general, that just increases your exposure to liability. And so you want to start thinking about setting yourself up with an LLC or a corporation. And that's those two, they differ in different ways. And we talked about that 2 weeks ago. But so you should start thinking about what type of entity you should form so that you limit your exposure and liability. And so that's one thing I would say, is that when do you think you should actually start your entity? If you haven't started actually engaging in your business and you're just thinking about it and you want to get it off the ground, I think it's fair to say, I would say, start earlier than later, because it's really a minimal filing fee. It doesn't take a long time to get set up. You can do it in half a day. You can get your tax identification number, your EIN number. You can get incorporated. It does not take long, and it's really not that expensive. So if you have it, I would suggest that you do it earlier on so that you don't have to worry about it later. And if something by chance does come up, you are protected with some type of either limited liability, or with a corporation, you have a lot more, like a stronger liability, and you're not so personally liable. So if you haven't started something, I would suggest do it right away. And if you've already started it, and it's exciting to get a business up off the ground, and especially if you're making money and you have customers and consumers. But like I said before, when you start to feel like you're dealing with a lot more people and you're gonna have to expand your team, you're going to have to expand your company, and you feel as though you're doing business at a level in which you should be protected, then I would say you absolutely need to look into starting and forming your company, because like I said, it's the best way to protect you from personal liability. And that goes to say also for real estate. So if you are looking to, invest in personal investment properties, which I know a lot of people do, a lot of my friends, a lot of my family, and my suggestion to them is obviously go talk to a real estate lawyer. But from just a general business standpoint, it's super important to to know that whatever happens from a contract standpoint, but also whatever happens to your tenants in the property that you own, you will be liable for that. You will be personally liable for that, and that is a terrifying thing, because if it's something you weren't even aware of, or somebody slip and fell, you have liability for that, even for their guests that come to that house. So I would always encourage, if you have any type of business that you're an employer, or you are dealing with people and there's an exposure to liability possibility, just file something. File an LLC and convert to a corporation later if you want to. Like I mentioned before, LLCs have a little less formality. There's a limited liability in it, but it really works for a lot of companies, especially if you're small. And then you have the option to convert to an actual corporation, like a C Corp or an S Corp down the road. So that's my answer for that, is if you know, the sooner the better is really the short answer. Okay, the next question was, this is a good question. It's, are you liable for pre-incorporation contracts? Thanks, Param, for these questions. Are you liable for pre-incorporation contracts? That's really great. It ties right into the first question, because lots of people do business before setting up their entity formally. So I'm sure that lots of people get into contracts, and it doesn't have to be a formal contract. It can be like, hey, this is a buddy of mine. He's going to help me do this. We just emailed back and forth, and so, we've got sort of this oral agreement or just this casual agreement, but it is an agreement nonetheless. Now, if you also have actual agreements that your promoter, who's signing contracts on behalf of the to-be-formed company, if your promoter is entering into contracts with vendors or partners or affiliates, then your promoter is taking on that liability personally. So if you are one of those, you're in a position to be the promoter, be very careful with entering into large contracts before you're actually formed and set up legally. Because unless the corporation, when you form it, or the company, unless the company approves of it, adopts it, and ratifies that contract, and basically takes on that responsibility and liability, that promoter is held personally liable for it. Or if the promoter is signing it on behalf of another entity that he represents, then that entity is liable for that contract. So it's important to remember, the earlier you incorporate or you register your business, the easier everything around your business becomes. You don't expose yourself and other people to unnecessary liability. So back to the first question, register your business really early. It's never, there is a time where it's too early, but it is really never too early. So if you have an idea, do a search, make sure you are not infringing anybody's name. And once you're free and clear, go for it, register your business in whatever state you think is appropriate. And then start with the contracts with, independent contractors, designers, engineers, whoever it is, and even co-founders. So, it's important for you guys to remember, personal liability and exposure is the number one question, and number one risk you have to assess along the way when you're starting a business and when you're entering into these pre-formation contracts, these pre-incorporation contracts. So I hope that answers some questions. I hope that helps. And the other question was, when you're a young company and you're starting and getting off the ground, how do you value your company? And then in turn, how do you value the equity that you may want to give out to your initial employees or your co-founder, your CTO? That is a very tricky question, and there is no real rule. Evaluation is very tricky along the entire process of the business, and lots of times there's an outside valuation that can be done when you're raising capital, or especially when you get to the larger rounds like Series A. There are a lot more measured and objective standpoints in which you can sort of justify evaluation and come up with a valuation. But when you're initially starting, you have an idea, and maybe you have a website, and you've got a couple of products, and you're just trying to get people who are passionate and interested to join and to work with you. That's really hard to assess. How much equity should I give this person? And I think there are many factors that come into this. Having done it myself for my own business, Eskme, it is difficult to figure out, but it comes down to the relationship you have with that person, the value that person is going to add, and how long is that person going to be part of your company? Is that person just something that you're outsourcing your dev to and you want to get it done with? Then, I wouldn't even suggest your equity route. I would think that that's going to be, that's going to be a contract position, and that's going to be something that you pay for. Now, if you feel like you want to bring someone on, like you want to bring dev in-house, then, and you like this person, suppose you start with a contract and you wanted to see how this person is to work with, how their work product is, do they understand the business and where we're heading, then, if you decide to bring them on, it's important to understand how long do you want this person to be with your business. Because when you give equity, there is a point there, when you give equity, you're basically saying to that person, you are part of this team. And there are many, many obligations that come with that, but there are also sometimes with a vesting schedule for equity, there are a lot of triggers and cliffs that come with that. And so it really depends on the type of person that you're bringing on. If it's a co-founder, that equity is much higher. You can get into the 15, 20%. Obviously, this is an obvious thing, but do not do 50-50 because that's dumb. You'll just potentially get yourself into a deadlock. So avoid a 50-50, but 49-51s if you want to. But a lot of times, co-founder does not mean that it's an equal split. Co-founder could mean that the person is doing it part-time, but they have the same ideas and vision, and maybe they bring something else like a network, or they bring the dev experience, or they're a finance person. So it depends on the relationship and how much that person is willing to offer, both in capital and in sweat equity, as well as their time, and how much value they bring to the table. So a lot of people offer out equity to advisors. When they're starting off, advisors take a really different role in a company than when you're a successful company and you're looking now to grow and scale. Advisors take a different role there. And so when you're in the initial stages of a company, you are looking for advisors who are, subject matter expertise. They have a large network. They have a reputation within the legal or within the industry or the community in which you're building your business. And so advisors sort of play a role in providing you validation. They are giving you the thumbs up that hey, we're not endorsing you, but we're sort of backing up these founders and the business, and we have authorities to do so because we are experts in this field. So advisors are sort of, they play a little bit of a hands-off role when you're starting. So we would always advise that when you value their equity piece, that is something that's going to be much lower. A lot of times it's 0.5%, or it's 1%, or it's, hey, we really enjoy this advisor. We need their validation. We need their network, and we need their introductions right now. But we want them to still stay with us and perhaps join our board down the line. And so we're going to make a vesting schedule. And what we're going to do is we're going to give points as an advisor. And then as we progress and as introductions are made and as we grow, whatever triggers we want, we can incentivize that advisor to stay with us by giving more equity along the way. So long as those milestones or thresholds or cliffs are met. So that equity question is always difficult. And I think the short answer is that you do need to assess your business. You should look at other businesses that are similar in different industries, but also in the same vertical as you. So take a look at what they were valued at when they got their seed round, when they did their Series A or whatever it is. You can do a lot of research on other companies that have similar business platforms, business models. So if you're an e-commerce marketplace, look to other marketplaces. Look at other companies that have enough journey that you can assess where you stand in comparison to their journey, and you can get a better sense of valuation. So you're not just slapping on like a $5 million valuation on an idea. I mean, that's generally not going to work, but you never know. It's possible. So it just really depends. And when you're thinking about giving out equity to potential members or advisors, I think the short answer is it comes down to what type of relationship that is, how long you think that person is going to be with your team, and how much value or capital is being added. Sorry, that's my dog. So I hope that answers the questions about business and equity and contracts pre-incorporation and formation. And I do have another question, and it is not really related to, sorry, give me 1 second. It's not really related to incorporation or equity, but it's a little different, and I'm going to try and answer it to my best ability. It is about privilege. And this is an interesting question because lots of clients come and they don't sign up, they don't engage the lawyer, but they want to have in-depth conversation with the lawyer about their business or their problem or whatever it is. And oftentimes you're giving privileged information. You're giving confidential information, sensitive information. And I'm not talking about like your date of birth and things like that. I mean, that doesn't need to be, discussed for the most part, but you're talking about things that are sensitive topic to you or they're close in nature to you. And some people want to have questions of when does that attorney-client privilege begin? Because when I'm coming to you as a client or a potential client, how much can I divulge to my attorney? How much should I divulge to my future attorney? And that question is really important for anyone who's looking to get legal help. It's really important for you to know that privilege begins when the relationship and the representation begins. So be mindful of what you are saying to your attorney or to your potential attorney. So if you're going to have a free consultation, which a lot of people provide, then be careful on what you're saying. But you obviously want to give enough information and truthful information so that the lawyer can assess whether or not they can actually represent you and they can actually represent you well. So there's a fine line, but the question really is that, or the answer really is that privilege, which is a very, very strong privilege, attorney-client privilege is it can rarely be breached. It can be waived by the client. That's a voluntary waiver. And sometimes if the probative value outweighs the privilege value, then courts can ask for the information and the privilege information between an attorney and client. So it is a very, very strong privilege, and even subpoenas do not require that privilege to be broken. So be mindful about the information you're giving, and be mindful that it starts when you actually engage with that lawyer as a client. Now, that leads me to another interesting type of privilege that came up, and it was sort of a interesting question about what's called, which a lot of people probably don't know, and I knew very little, but I did some research and I looked it up, and it was interesting to know that there is something called a labor relations privilege. Now, that is basically a privilege that's also very strong, and it is it's very similar to like whistleblowers laws, where if you are an employee and you have some type of grievance and you're going through a grievance procedure or you're going through a grievance process with your union, then you are assigned to a union representative or like a grievance committee representative. And now that's another privilege. And that privilege is any information that you give to that representative through this process, through the entire procedure of your grievance committee and procedure. That information is actually highly privileged. And that changed after the Peterson versus State, and it was an Alaskan case. And it had to deal exactly with these facts, that there was an employee who was trying to submit a grievance letter and a complaint against their employer. They went through the labor relations union process, and they gave sensitive information. They gave out their complaints. They named people. They talked about specific incidences, and then the employer. And before this case, the employer was able to go get all of that information. They were able to review all the records, all of the evidence. There was no such thing as that privilege. And so, as you can tell, that is going to be detrimental to the process of the grievance process. Obviously, it's not anonymous, and that would change the incentive behind, and it would de-incentivize employees from actually bringing any kind of complaint. And so after the Peterson case, the rules changed, and it's very, very difficult to invoke a new type of privilege. Usually the privileges that stand under the legal industry and regulations are pretty set in stone. It's like attorney-client privilege, it's marital, there's a marital privilege, and now there's also a labor relations privilege, which has been introduced a couple years ago. And it's interesting to see these things take place because I think we're going to see it come across a lot of different industries, and a lot of professionals are probably going to, I don't think it's only limited to the healthcare and to legal industry. I think there are going to be a couple more instances that we see in a couple of years. But the labor relations privilege is an interesting one because it really safeguards employees who have these complaints from allowing any of that information, that sensitive and privileged information, to come into an actual court of law. It cannot be considered evidence. It won't be admissible at trial. And so it's really interesting to be aware of the type of privileges, no matter what field you're in, whether you're a business owner or you're a labor union employee, or if you're a patient with the PCP or a hospital. It's really important for you to know what type of privilege you have with your provider or your employer or your lawyer, and also very important to know when that privilege begins. So that goes back to the initial question. Is when does that privilege begin? For an attorney, that privilege begins when you actually engage the attorney in a legal representation. So that's all. I hope this was informative. I hope you enjoyed the questions and the answers. And if you have any questions about these ones, let me know. Shoot me a message, shoot me an email, or let me know what you guys thought. Leave comments. I'm going to post this. And if you have questions for next week that come up, please send them to me. I love doing this, and I'm going to try and do this every week. I'll move this to an earlier time, probably 10 a.m. Pacific. So, send me questions and have an awesome weekend. Thank you.